Okay, my name is Michael Jonathan Numa, and I'm privileged to be the managing partner of MJ Numa and Partners LLP. And this is our headquarters here in Abuja. We have some satellite offices across the country, especially in Lagos and in Port Harcourt. We're basically a mid-sized dispute resolution and transaction advisory law firm. A chunk of our work is dispute resolution, international and domestic arbitration, and indeed courtroom arbitration in corporate commercial disputes. We do a lot of advisory work across board, cooperation and indeed government agencies on shaping policies, and we do substantial part of our practice as government liaison practice and legislative liaison, where we assist lawmakers in bills drafting, motions drafting, as well as advising on amendments of relevant legislations and indeed the Constitution when the need arises. So that's a cocktail of our practice here in MJ Numa and Partners. It's a very organic law firm, substantial members of staff, at least 40, including myself, who's privileged to be the managing partner. So we're the new kids on the block. Well, I was called in 2010 into the Nigerian bar, and I started off my practice almost immediately. And I started with a traditional dispute resolution family law firm known as Karina Tunya and Company. Karina Tunya and Company is known as the pioneer law firm in the city of Abuja, established as far back as 1981 by a very fine gentleman, Chief Karina Tunya, Senior Advocate of Nigeria, who happens to be my mentor. And I stayed there from being a pupil counsel as a first year associate and rose to the level of managing partner before I exited the firm a year before I started my practice in pursuit of the rank of Senior Advocate of Nigeria. Like I said, it's a family law firm. So at the material time when I was ready to aspire to the inner bar, there were no provisions for equity partnership, which was one of the requirements as stipulated in the guidelines for the conferment of the rank of Senior Advocate. So that was the only reason why I left that practice formally. But I can tell you that I still collaborate with the firm in every respect. Most of the portfolios that I manage today with clients that I've always had while I was working with Chief Karina Tunya, and he was gracious enough to actually lay a good number to me, and he still does that because my boss is actually semi-retired from practice. So there is no division, as it were. It was as a matter of expediency. That's why we started our own practice, which has been a going concern within the practice anyways, but substantially that. But besides having that initial relationship with my mentor and principal partner at the material time, I had cause to have mentorship from several lawyers across board. So I had a cocktail of experience from diverse lawyers with different perspectives, which had shaping me substantially, I believe, to the height that I achieved at a very unexpected period where most people didn't expect that it would have been this fast. But I give thanks to God for the order in which He has managed my steps to this level. Um, 2022, specifically November 28, 2022 was when I was admitted formally to the inner bar. The Legal Practitioners Privilege Committee had preferred us for the rank on the 28th of September 2022, and that was when the formal announcement was made after the ultimate assessment for the final interview and the plenary considerations. So we were formally pronounced by the Privilege Committee on the 28th of September 2022. But the conferment ceremony, which is largely ceremonial, where we formally took our oath of office and were allowed to adorn our full bottom wig with the full admission into the inner bar, was actually in November 2022, specifically on the 28th. Well, I'm not the youngest senior advocate of Nigeria so far. The profession has had those who were preferred, younger than myself, either by age or by in terms of call. But on the hierarchy right now, at the Yinaba, I'm the youngest on the roll, by virtue of the fact that I'm just 12. I was preferred when I was just 12 at the bar, now turning 13. And I was preferred when I was just turning 37. But I could tell you that a few members of the Yinaba had been preferred when they were 36. I know a few names of individuals that were preferred when they were 36 and when they were about 12, 13 as well. So I don't think I was the youngest ever to be preferred, but of course amongst the youngest. But now on the roll, I'm the youngest at the inner bar. So you could say that I'm the youngest member of the inner bar for now, but not on the criteria that I was the youngest to be ever preferred. That could be a little bit misleading. Yeah. Law has always been something that I was very endeared to for diverse reasons. For starters, I'm a first generation lawyer. I don't have a legal background. None of my parents nor grandparents were lawyers. Like I tell people all the time, in my father's small community in an island in southern Ijoba State, I'm the first individual to ever qualify as a lawyer. But this is a small community, but so I didn't have the privilege of a second generation and third generation lawyers that have a foundation laid out for them before mine. And I didn't have that burden of inheritance, as it were. So my pursuit to the inner bar was from when I was called to the bar and commenced my mandatory youth service. I was privileged to be exposed to an array of very senior counsels. I got admitted into the law firm of a senior advocate who I saw carried himself in a very special way. The privileges they enjoy, the responsibilities that the society beholds on them, and the way and manner they comported themselves, the excellence they actually exhume when they are in and out of court, and in several other engagements. It was a big motivation to me because I felt it was those were lawyers of a class of their own. There's this charismatic way the rank propels you to. Even when they come out, the sartorial elegance that you see of a member of the inner bar, it's exceptional. So I didn't think it was something that I could consider otherwise, not to aim for the best and aim for the best and aim for the top. But aiming for the top was not as a result of just mere desire. It was hard work, perseverance, and strong resilience. I watched very essential senior lawyers. I watched some very brilliant and talented lawyers conduct themselves. I followed them. I was their hidden mentee. I was steadfast in taking processes from the likes of Chief Akinjide, Fidelis Odita, Senior Advocate of Nigeria, and a host of those lawyers. I kept that consistency over the years, and I still do actually, to ensure that I go beyond just the scope of my immediate practice to venture into what is actually happening in the legal community. And when I was writing for This Day Law in the column known as the Canvas Legal for about 5 years, I had the opportunity to have a global perspective of how law should be practiced and how lawyers should conduct themselves, and the duty that we owe the society as lawyers. It's not about just lining our pockets and ensuring that we get fees and clients pay us and we carry ourselves as elites in the society. It was about the duty we owe the society. And I can assure you that whilst the rank comes with some seeming privilege which people just assume. I will assure you that the responsibilities that comes to the rank, leadership and otherwise, outweighs those privileges. It dwarfs them completely. So while I'm very grateful to God and indeed the profession for this admission, I have an Herculean task to maintain that excellence that actually propelled me to pursue the rank. And as God will have it, on first application, I was preferred and eventually conferred. And also mentor junior lawyers who are coming after us. The expectation is huge. People see you, say, okay, young lawyer, let's see what the stuff is made up of. And even if I don't consider myself to be under pressure to meet certain expectation, I believe that the rank is an icing on the cake. It's not a cake. So you have had the right framework to become a member of the inner bar. The conferment is only an acknowledgement of that excellence that you've actually demonstrated over the years. And I believe that it can only get better. And I'm very grateful for the very senior lawyers that have gone ahead of us and have set the path. Chief Joker Ajayi, Chief Williams, Chief Kende Shofala, the FR Relays and Demola Relays, and very, very senior lawyers. For me, I was very particular, and one person who actually directed my path amongst the numerous mentors that I've had is Dakolani Peku. He gave me a different orientation on how I should view the practice of law and how I should not relent in pursuing my ambition of anything I want to achieve within a very reasonable time. I shouldn't consider myself, oh, I'm too young for this, or I'm not prepared for this, let the older ones go forth. He just gave me the rules that, listen, once you're prepared for it, hit it and pursue it vigorously, and God will direct your path. And this is where we are. The rest is history. Well, I consider pupillage very, very, very crucial. It's a shame that most lawyers are not ready to actually sit down, relax, and learn the ropes before venturing into something else. It is quite intriguing that the diverse areas of law right now emerging, fintech, tech law, medical law, some very diverse areas of law that are a departure from the traditional dispute resolution. And it is easy for anyone to say that, dispute resolution is actually superior to any other aspect of law. That's not correct. Those who do non-contentious work do very specialized and very excellent work as well in their own area of practice. As a matter of fact, there was a report 2 years ago or 3 years ago from Thomson Reuters or McKinsey that gave a prognosis that 70% of the work of lawyers in the next future will probably be non-contentious work, just more or less advisory work. And the scale of artificial intelligence and when you see robot lawyers now arguing cases in court would probably take out jobs of redundancy in the legal profession where people are not ready. Where we have templates of contracts, templates of legal arguments, templates of opening statements, templates of brief arguments for virtually every subject matter that has been pronounced before. So you will see that it is not just the traditional way of doing things that would make any lawyer succeed. COVID gave us a typical example that we need to depart from the norm. And with that experience in COVID, it's created and indeed bettered a new normal. And lawyers were trying to adjust. In other climes, things have actually changed radically. But unfortunately, we're going back to our usual here in Nigeria that we still fall back to our fiscal hearings and I just finished an international arbitration on Monday where all the witnesses, the full evidential trial was taken virtually. And we had little or no glitch in the conduct of the proceedings. So I think that young lawyers should be patient in acquiring knowledge from good, ethical, professional law firms before venturing into whatever aspect of law they want to. It is good to have a general background of what law is before you now think of specialization. Specialization is key. I'm for specialization, but it's always important that you have an all-round experience. Maybe not very deep to call yourself an expert in that area, but it is very important that you get the basics. Apart from the black letter law experience you had from law school or from the university, having law in practice is a different ballgame entirely. So maybe 5 years with a good law firm can give you the requisite background for you to now venture into whatever you want to do. Like I said, practiced law for more than 10 years as an adjunct to a firm shortly before I aspired towards taking the rank. And like I said, if not for the requirements as stipulated in the guideline, which was they were not readily available at the material time from the structure we did operate under, perhaps I wouldn't have bettered my own practice, which I don't consider my own practice. It's actually an institution which we try to build where people can come and they won't lose their individuality or the identity that they came up with. They would come and feel among. The firm has a clear succession plan with the blueprints for those to take over. For folks like us, I don't intend to practice law all my life. I intend to retire at a very reasonable age, say perhaps before I'm 60, so I can take a back seat for others to actually come after. So that's my perspective of that. But I'm for pupillage, I'm for training, I'm for capacity building. Before anyone thinks of being an expert in any field, you need to actually garner the requisite experience and have a foundation that is solid. So moving forward, you won't have any shaky basis for anybody to question your competence, as it were.
Thank you so much, Legacy. And as an individual too, I don't know if I can make or solicit, because for some of our young lawyers that are just coming out from law school, some of them are yet to go for NYC. So I don't know if your firm is really available to mentor some of them, maybe just working to come and observe how the law firm is going on, and so for some of them that would want to actually learn the rules. So I don't know if you are open to welcome a few, maybe 1 or 2 or 3 that are open to mentorship or populage.
Of course, we already run some form of a pupillage scheme, mentorship scheme. We admit interns from university that are yet to go to law school, and we also have certain allotments from the Nigerian law school at every point in time when they are in the course of their court attachment and chambers attachment, and we try to inculcate our culture in them. By making them understand the perspective of how law should be practiced from our own standpoint. And to that extent, our doors are always open to mentor lawyers for the best of our ability. We don't have reservations whatsoever. And like I said, all of us were mentored. All of us were given that opportunity. So we're happy to actually give opportunity to that.
So that brings me to the second to the last question of the day, and which is, I really like you to, how do I put it down? I really want you to actually, advise young lawyers. What is your advice away from the populage? What do you think young lawyers, from the age of 1 to 7 years, what do you think should be the foundation of their practice?
Well, I think not just for young lawyers, in my perspective, everyone in the legal profession should ensure the continuous quest for capacity building. The older ones perhaps might be more experienced, but young lawyers, the only way you could distinguish yourself and have a seat on the table at every material time if you bring something to the table. No one gives anyone an opportunity a la carte. You must have value that you want to add. So to the young lawyers, I'll say continue to build capacity and be patient that the legal profession might not just give you all the resources you want for now. It takes a while. We all grew through stages and eventually got into where we are, and we're still striving to actually get to greater heights. So the young lawyers should be more resilient, patient, and indeed pray to their God all the time. Have trust in God. People get really surprised when I mention to them that I started practice without a salary, and I've never earned salary as a young lawyer in my entire legal career. My relationship with my firm was basically on the more or less like a volunteer basis. That's why we came in. Just come learn the law. There were no remunerations, as it were. Once in a while, there could be some small bonuses for us to take care of our travel allowances and thereabout, but there were no fixed remuneration that monthly you get a paycheck or anything. I don't personally believe in that moving forward, because I have a different structure and a different mentality the way I run my practice, because we have a clear payments and remuneration structure. However, I think that the goal, it's not about the remuneration. As Chief Kana Gabi will tell you, no lawyer can pay another lawyer. What you make of yourself from the instructions you get personally and your advice personally and your deal personally is a lot more profitable than the one that you get paid by another colleague for maybe doing some third-party work. So we shouldn't be so focused at the formative age of our practice to consider money. Money is a big deal because there's enormous hardship in the country, but it shouldn't be the center of our focus. By the time you are so money driven, you tend to scare people who might be willing to give you a chance, an opportunity on the table away from that, and that's a major concern. So I just employ young lawyers, which I belong to that category, if you may, to be patient, ensure that they continue to build capacity, and above all, they should be prayerful and put God first in all their pursuits, and the sky will be the beginning point. Well, a good number, but one of those cases that come to mind is my case of United Bank of Africa PLC versus Vertex Agro Limited. That was a commercial banking transaction that was quite a novel area of law. The genesis of that case was that my client's monies were siphoned from his bank account through an online means by third-party infiltration, and there were clear conditions stipulated in the fine prints of the guidelines in the account opening package, as well as the subscription notes for the online banking, that impairs us from actually seeking relief, because there were exemption clauses that completely exculpated the banks from liability. But we beseeched the court to contend that those exemption clauses were not enforceable, and that those clauses were against public policy. And we also invited the court for the first time to pronounce on the provisions of Section 34 of the Cybercrimes Prohibition Act, which enjoins banks to actually make a refund of any unauthorized transaction from a customer's account within 72 hours. And when we took out the writ before the High Court of Niger State, the banks brought up a very blanket defense on that premise, but we were able to convince the court and convince the Court of Appeal. The matter is now at the Supreme Court. Yeah, so I got an exceptional fulfillment because it was a very novel area. We were inviting the court for the first time to make some very proactive pronouncement that affects the generality of the masses. Virtually Every household gets those complaints once in a while that you just see some unauthorized deposits from your account, you make ATM transactions, you don't get value, but the monies are out of your account. So those sort of things. But by the time this Court of Appeal pronounced on the provisions of Section 34, it gave clarity in the banking sector as to what is obtainable when such circumstances arises from banker-customer relationship. So that was one very material case that I felt was my own contribution to legal profession. It was quite a recondite issue at the material time, and it was an issue of significant public importance. But a few other cases have come in the political space, a few other cases have come in election litigation, land transactions, and other very notable pronouncements that the court has made, which we've been privileged to be part of as trial attorneys.
Thank you so much, Hennessy. It's been a wonderful time on the show today.
Thank you.